Give him this copy, and we can take that other one back, that one to sign.
Just swap them.
Yeah. Okay, we're on the record in cause number 327572, the state of Texas versus Sharon Berry. Mr. Berry, would you please raise your right hand? Mr. Berry, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay, Mr. Berry, you may put your hand down. Mr. Berry, um, the document that's before you is titled Bond or Standard Bond Conditions in County Court at Law Number 2. I'll go over these bond conditions with you. Following arrest or accusation in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the following additional conditions. Number one, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition? Condition number two, the defendant shall submit to testing for drugs and alcohol at any time directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submits to a test for drugs and alcohol and the test indicates the presence of drugs or alcohol in the defendant's body. And that's pursuant to Texas Code of Criminal Procedure, Article 17.44 A2 and C2. Condition number three, the defendant shall not communicate either directly or indirectly with an alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. And four, a defendant who has been arrested or accused of any subsequent offense listed under section 49.04 through 4906 of the Texas Penal Code shall not operate any motor vehicle unless the vehicle is equipped with an interlock device mechanism that makes impractical the operation of the vehicle if ethyl alcohol is detected in the breath of the operator, and said device shall be installed at the defendant's expense with written verification of such installation being submitted to the court on or before the 10th day after arrest. Now, you have a DWI second, and it falls in that category because it is an offense that falls in the category of section 49.04 through 4906 of the Texas Penal Code. And it is a subsequent offense that falls within that category. So therefore, you'll have 10 days to install this device, 10 days from the day's date. To install this device on any vehicle that you own or operate. Do you understand? Okay. Now, you'll have a copy of that. So within 10 days, you need to provide verification to the court, to this court, of the installation of this device. Okay, you could bring it to the court, bring it, so that we can have proof. And if you fail to do so, this court can revoke your bond. If your bond is revoked, then a warrant can be issued for your arrest.
As of this moment, I do not even own it.
Okay, any vehicle that you own or operate. All right. So that applies if you own or operate a vehicle. So any vehicle that you drive, if you're going to drive somebody, it has to have interlock device on it. Okay,
For 10 days? For 10 days? For how many days?
No, I said if you're driving a vehicle, it has to have that device on it.
For how long?
Well, right now, during the dependency of this case, during the pendency of this case. Okay.
I'm walking right now.
Okay, well, it's fine. Well, but if you get a vehicle, if you drive somebody's vehicle, you can't drive it unless that device is on it. All right. All right. Now,